Your attendance shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have about 5.5 hours of argument time that's been requested this afternoon, so please keep that in mind as you're asking for the time for argument. Remember that we have your briefs, we have your record, we're fully familiar with the facts of your case, so ask only for the time that you absolutely need to make your arguments. First case is People versus Ricardo Lopez. I'll do 5 and 2, and you said 2? 2. Lindsay versus CG Maiden member. 5, 2, and 5. Zion is submitted. Bax versus InterEnergy Holdings. 5, 2, and 5. Solo Group versus, thank you, Solo Group versus Harris. Submitted. People versus Jerry Anderson. 3, 1, and 3, thank you. Art Capital versus Bank of NT. 5, 2, and 6. Contreras versus Mall 1 Bay Plaza. 5, 4, 2, and 5. Webb versus New York City Transit Authority. 5, 2, and 4, thank you. Bellet Construction versus La Rocca. 5, 2, and 5. Fernandez versus Bright Leasing. 5, 2, and 5, thank you. Warnberger versus Lucani. Oh, there you are. I'm sorry? You said you asked for 5? Okay, I'll give you 5 and 2, and I'll give you a respondent who is not here yet. Understand they're running late. I'll give 5 minutes. Thank you. First case, People versus Ricardo Lopez. Oh, did I not? I'm sorry, I didn't call the last case. Franpo Realty versus Power Furniture is submitted. Thanks. People, thank you. You may begin.
Good afternoon. Sam Claflin for defendant appellant Ricardo Lopez. Mr. Lopez's 2004 plea was not knowing, voluntary, and intelligent, so its associated conviction improperly enhanced his sentence as a predicate in this case. Given his illegal sentence, the court should vacate his predicate felony adjudication without remand and otherwise affirm. The 2004 plea court did not produce a record affirmatively showing Mr. Lopez's guilty plea was knowing, voluntary, and intelligent. First, the 2004 plea court conflated the guilty plea with the indictment waiver in the case, making the record unclear as to the consequences of the plea. The court did this by introducing the plea concept before abruptly and immediately jumping to the indictment waiver concept.
Counsel, the defendant didn't take an appeal from that conviction, did he?
That's correct, Your Honor. That fact is not dispositive at all, Your Honor. In fact, there are several cases we cite in our brief in which courts have said that that fact alone does not preclude a later predicate challenge on the basis of a plea voluntariness claim.
How do you get around Harris?
Excuse me?
How do you get around the case of Harris?
Hatteras?
Harris.
Could you remind me, Your Honor, of the relevant proposition you're referring to?
The Boykin rights, right? I assume that what you're saying that the defendant's conviction was not constitutional in that the court did not properly advise the defendant of all the rights that he was waiving. The court advised one out of the 3 Boykin rights, right?
Thank you, Your Honor, for
Harris
reminding me.
stands for the proposition that the court doesn't necessarily have to notify the defendant. There's no particular litany with regards to Boykin.
There is no particular litany. That's right, Your Honor. Part of our claim is that the court did not actually tie any of the Boykin rights to the guilty plea. In this case, the court did mention forfeiture of a jury trial, but it tied it to the indictment waiver. There's no mention whatsoever of the right to confront or the right to remain silent. I understand that no particular litany is required. However, in the totality of the circumstances, along with the conflation of the indictment waiver and the guilty plea and the other arguments that we've presented, we believe that the totality of the circumstances illustrates that the plea was not knowing, voluntary, and intelligent. So further, this was a serious offense that required a particularly robust colloquy. It was a D-violent felony carrying a 4-year prison sentence and 5 years of post-release supervision. In Conseco—
Sir, what relevance, if any, is there to the fact that your client had previously pled guilty on approximately a dozen, or maybe it was 14 occasions, and so the inference being that he had some familiarity with the plea bargaining process?
Mr. Lopez did have prior pleas at the time of his 2004 plea. I'm not aware of any case upholding a plea as knowing, voluntary, and intelligent solely on the basis of prior pleas, Your Honor, so I would first point to that. So the severe deficiencies in the plea allocution here were not outweighed. Further, Mr. Lopez was a special education student who left school after 8th grade and whose primary language was Spanish, so we cannot infer his understanding from those prior pleas. Several occurred significantly before the 2004 plea. They wouldn't have been fresh in his mind, and several were to misdemeanors, likely entailing minimal allocution. Another reason that the 2004 plea was not knowing, voluntary, and intelligent—
Counsel, there was no court interpreter?
There was no court interpreter in the 2004 plea or in the plea in this case, Your Honor. Mr. Lopez pled guilty early in the case in 2004, less than 1 month after counsel was assigned. Courts have looked at that as a factor in the plea voluntariness inquiry, such as in Conseco and in Tyrell. Further, the record does not show that Mr. Lopez consulted his attorney about the constitutional consequences of the plea specifically, though they did discuss the indictment waiver. Briefly regarding preservation, counsel below argued that the totality of the circumstances do not demonstrate that the 2004 plea was knowing, voluntary, and intelligent. That's the exact same theory we're advancing on appeal. The claim is preserved. As to remedy, we're asking that this court vacate Mr. Lopez's predicate felony adjudication without remand and otherwise affirm. The reason for that is that there's simply no need for a remand in this case, Your Honor. Mr. Lopez has already served Mr. Lopez has already served his sentence, and the length of that sentence was within the permissible range for someone in the first felony offender category. This case has granted exactly that kind of relief in these circumstances in the Martin case, and the Second Department just last year in the Lynch case also granted the exact relief we're seeking in these circumstances. I would further add that the prosecution in the record below did not offer any other predicate qualifying conviction for remand. So together, our arguments illustrate how Mr. Lopez's 2004 plea was not knowing, voluntary, and intelligent, that his associated conviction was improperly used as a predicate in this case, and the court should vacate his predicate felony adjudication without remand and otherwise affirm. Thank you.
Thank you.
May it please the court, I'm Philip Tisney for the respondent. The predicate plea in this case was valid. The colloquy could have been a little longer, maybe it could have been a little bit more detailed, but there was no question that this defendant knew what he was doing. This was not his first—
How do you respond to your adversary's position that I think the record bears out that the court only discussed one of the 3 Boykin rights? I don't think there's any dispute about that. But your adversary has pointed out that the court conflated the waiver of indictment with other rights. How do you respond to that?
Well, we just disagree about what the record shows. The court discussed the waiver of indictment like it was required to do, and then it moved to discussing how he was giving up his jury trial rights. Now, of course, the court didn't mention the other 3 Boykin rights, or the other 2 Boykin rights, but it's not required to do so. So we just disagree about what the record shows there. And even if you think that there was some lack of clarity from this particular record, given the entire circumstances. I don't think there's any real question that this defendant knew that what he was doing. As your colleague mentioned, this was his 14th plea at that
I have
time.
a
I think he
follow-up.
asked,
Go ahead.
I think,
I defer.
I think the question was posed. I don't know that it made any statements about what the relevance of that, so why don't you answer it?
Fair enough. The relevance, of course, is that this is somebody who was deeply familiar with the criminal justice system, having accepted 14 pleas prior to the 2004
So that means any
plea.
error that's made by lawyers on argument, how should I weigh that then? If I should take a defendant who's never been to law school, who's never tried a case, who's never any of that, the fact that they've been in the court 14 times, they would understand about things like Boykin rights that the court didn't seem to get straight in this case?
No, Your Honor. I think what we're saying is that it's one piece of a broader puzzle here that together adds up to a conclusion that this defendant's plea in 2004 was knowing and voluntary.
And does that conclusion consider, one piece of that, does that consider that this person had special needs or was in special needs classes or anything?
I mean, I think to the extent that that is something that's in the record here, yes, we can consider that. You know, the point that we made in the brief is that, you know, being somebody who receives special education services in school does not equate with the kind of mental impairments that courts typically require before finding that a defendant who is otherwise known.
Well, we're not talking about incapacity, but you're taking it to another level. You're expecting some sort of legal understanding. That's what you're inferring. So you're placing that on the defendants, that they should have, their prior plea, sort of gives them some special legal understanding of these very...
No, just that their familiarity with
rights.
having done this is something that a court can consider in just determining whether, in the 14th or 15th time that they're doing this, that this is something, that this is a process that they understood.
Of course,
I think it's significant that...
I'm often struck by, given this is a common event every day in the courts throughout the state, the taking of pleas, right? And yet it's so idiosyncratic. And so the defendant may have taken pleas on a number of occasions, and as your friend pointed out, to varying levels of offenses. It may not have all that much familiarity with any one particular litany or catechism of recitation of rights, given, again, the idiosyncratic nature, in my view, of how plea allocutions are often taken.
No, and that's right, and I don't disagree with my colleague here. You know, there are some pleas like this one that are less detailed than others, and of course, the mere fact that he has pled guilty 14 times does not by itself work as a silver bullet to excuse any errors that there might have been in the colloquy. All we're saying is that that is one factor and many factors to consider in evaluating whether this plea was voluntary. It's not just that he had pled guilty 14 times before, it's that he had talked about this with his lawyer at the time.
Then perhaps it's a better argument to just say what you think he did that makes it important. But the fact that he 100 times, I don't see the difference here unless he's got some special degree in Boykin rights and
So, counsel,
et cetera.
sorry.
Fair enough. It's not just that he's done this before, it's that he's talked to his lawyer about it, he was getting a good deal, and of course he didn't file any appeal from the plea at the time. All of those things together add up to the conclusion that this was a knowing and voluntary plea.
Counsel, my question pertains to the statement by your adversary that the defendant had no interpreter present at the time of the allocution, either in the first 2004 conviction that's at issue here or in the one that took place later in 2017. So was that issue raised below, that that an interpreter was required, or is there anything here?
I'm not aware of anything in this record, either on the 2004 conviction or on this conviction, suggesting that an interpreter was required. Of course, there wasn't an interpreter at the plea in this case. the defendant, engaged in the colloquy in English, and there isn't any claim in this appeal that this plea is invalid. I have no information about what his English language proficiency is, but they don't make any argument with respect to this particular plea that his limited English language proficiency rendered his plea in this case involuntary.
Thank you.
Thank you. We'd ask that you affirm the conviction.
So, counsel, if I may, how is this issue preserved as to the lack of an interpreter?
So counsel below argued that in the totality of the circumstances, the plea was not knowing, voluntary, and intelligent. And so our preservation argument here is that everything we've expressed in our brief and here today goes to that claim and is therefore preserved.
And where is it raised that his predominant language was Spanish and he didn't understand?
In the pre-sentence report, Your Honor, there's an indication that Mr. Lopez's primary language was Spanish.
Counsel, primary language aside, was a request made for an interpreter, and was such request denied?
Not on this record, Your Honor. And so the presence or absence of an interpreter, again, is just one piece of what's going on here. So I would reiterate that the court entirely conflated the guilty plea with the indictment waiver in this case. While the court did mention the right to a jury trial, the court tied that right to a waiver of indictment, not to the guilty plea. And so that's a glaring error in the plea allocution here. As to the prior cases, again, I'm not aware of any case saying that upholding a plea as knowing, voluntary, and intelligent solely on the basis of a defendant's prior pleas. And so unless Your Honors have any further questions, we'll rest on our brief.
Thank you. Thank you both.
Thank you.
Lindsay versus CG, maiden member.
May it please the court. My name's Kevin Brennan. I represent Appellant 5-Star. We're asking for the court to reverse the award of summary judgment in favor of plaintiff because the evidence that 5-Star offered in opposition presents a question of material fact.
Counsel, what difference does it make whether or not this individual slipped because there was water on the rung he was on, or whether he fell because his shoulder popped and he couldn't grab onto the wrench or whatever? He was on a ladder that was not secured, and he was doing work that was within 240. How did this ladder serve as an appropriate safety device?
It wasn't an adequate safety device, but it doesn't make any difference, Your Honor, whether he slipped or he fell off the ladder. What does make a difference is whether he suffered the injury as a result of that inadequate safety device. We've submitted in opposition several writings, some of them created by him, one of them by a doctor with a history from him. And they present a question of fact, not about how he injured his shoulder on the ladder, but whether he injured his shoulder at all as a result of slipping or falling or any application of the force of gravity because of the inadequacy of the safety device.
But wouldn't that go to damages? It wouldn't go to liability because 241 is solely a liability issue.
But 241 liability results when the inadequacy of the safety device, which I concede, causes an injury that's gravity related. For example, I'm not good at remembering names of cases, but whether it's Ross or one of those cases where someone hurts their back and it's conceded, Court of Appeals case, that it's an inadequate safety device, but the injury wasn't from the direct application of the force of gravity. In summary, the documents that we submitted contain evidence from plaintiff himself that this was like repetitive stress injury. The most probative, I think, is the C3, the workers' compensation document that he signed and submitted underneath the thing that the form statement that says this is you're swearing to tell the truth, and he's asked two questions. The question number 5, this is on page 531 of the record, near the bottom of the page. Question number 5 is, what were you doing when you were injured or became ill? At work, holding valve, started feeling pain in shoulder. Question number 5, how did the injury or illness happen? For example, I tripped over a pipe and fell on the floor. The answer is over time, due to heavy pushing, pulling, lifting, developed tears in my right shoulder. Chronologically, the first 4 documents submitted, including the incident report that he himself completed, and it's hard to read what he said, none of them show the direct application of force. None of them support a liability under 241. On his own, the incident report, the evidence in the record doesn't suggest that it was submitted. I'll just cut to the quick. The incident report says this: on the 14th floor, there was a leak coming from a leaky valve I was holding. I climbed a ladder with 2 wrenches and valve plug to stop the leak. I tightened up the plug on the leaky valve. My shoulder gave way, a snap in my shoulder, and dropped the 2 wrenches. There's no mention of slipping or falling off the ladder at all in that statement. So, yes?
But wasn't there another person there that saw the ladder turned over, saw the plaintiff on the ground? Again, it doesn't sound like it was, I mean, certain
yes, Your Honor,
facts
there was. His colleague at work testified at a deposition and corroborated the story, but that's resolving credibility. Was he telling the truth? And he has a relationship with the plaintiff. There's evidence in the case from which there's a question of whether it happened. He went to the doctor.
Just one last question. Doesn't he say that he grabbed onto the wrench as he was slipping, so that the slip occurred and he grabs onto the wrench and that's how the shoulder pops and everything else? I mean, if you look at this from a perspective of, so maybe he's comparatively negligent in some way, that still doesn't avoid your...
But that's his story, that he slipped, and that's his friends corroborate.
Well, there's no other story.
But all the documents that we submitted in opposition, that he's not saying any of that. That's not in there.
Sir, you just said it was his story. You said it was his.
That's the plaintiff's story. But then when he testified at his deposition, but that's not what he said in his C3. That's not what the doctor's record that took the history from him at 511 and 5.
Well, those questions might have been posed differently. I don't know. Anyway, I think there's another question.
Sir, were there space limitations on any of these forms? Sort of curbing or limiting the plaintiff's ability to expand upon
the very first form, there was a space limitation, and the plaintiff raised it, and he said that there was a space limitation. Of course, it also said on it, you can go to the other side to complete it, and there's, in the record, I think it's unclear, we don't know if he ever did that. It's only that one side that's in the record. Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. Let me apologize in advance. I think I misunderstood my adversary's argument. I thought his argument below was that because the plaintiff's accident report and other medical records didn't actually state a 240 sub 1 labor law cause of action in haec verba, there's an inconsistency. I believe that's just flat out inconsistent with your decision in Hill. If you shepherdize Hill, you'll see that there's 2 subsequent decisions, Rahm and Cuevas, which say exactly that. To Judge Renwick's point, this is what the plaintiff said about the accident. It's on 160. As I am tightening the plug, and again the ladder was wet, and I was tightening and I slipped off the ladder and fell, but I tried to hold myself up. That's when I heard a pop in my shoulder. That's what he's referring to in the pop. And I couldn't hold myself up anymore, so I just fell off the ladder. Mr. Kelly, who's a witness, so this is not an unwitnessed accident, specifically said on 420 he heard the wrench drop, and he says, quote, "You can imagine a 100-pound wrench hitting the floor makes a decent sound. That's when I turned around and plaintiff seemed to have fallen off the ladder into the pipe. And then he says on page 467, I saw him dangle on the pipe there. I know he fell off the ladder or the ladder fell out from underneath him, you know. But like I said, I can't give you a blow-by-blow. It really happened that fast. And finally, on 468, he said, quote, the ladder had fallen away and it was kind of hooked on his foot for a minute there. So our position is that you have an unsecured ladder and a wet ladder, both of which are violations of the labor law. And with due respect to my friend, I can't stop him from making a damage argument at trial. He can argue that the damages that the plaintiff sustained had nothing to do with the 240 violation, and he's free, if he can do it, to say that these are pre-existing injuries, the pathology of which would have occurred anyway. But if you look, you have two new decisions, and I just want to tell you, I gave them to my adversary beforehand. The Sangaray against 985 Bruckner Boulevard, it's 2023, New York Active Lexus, 287. And a case Pinzone, P-I-N-Z-O-N, against Royal Charters, it's at 211 AD 3D 442, both of which say that that argument goes to damages. One final point, and I'll sit down. My brief was inaccurate because I missed one case dealing with a leaking ladder. I also gave it to my adversary, and I just want to give you the site. It's called Golubowski, G-O-L-U-B-O-W-S-K-I against City, and it's at 131 AD 3D 900. If there's nothing else, I'll sit down. I'll let my adversary.
Sir, are there any material inconsistencies between your client's deposition narrative and his coworker deposition narrative on the one hand, and the various documents that they proffered in opposition to your motion?
Absolutely none. Not including every single fact on an accident report is not an inconsistency under Hill. Hill specifically says that. And that deals with something where the plaintiff did not say that the ladder was wobbling, and this court said, you don't have to say it was wobbling if the other evidence is there. So I think when you look at the totality of the evidence, there's not one thing that the plaintiff said that was inconsistent. And if you look at the documents as a whole, congruently, you'll see that they have a remarkably consistent story, including in some of them that he fell off. So that's not an inconsistency that would thwart summary judgment. So,
counsel, to the extent that your adversary concedes that indeed the ladder was an inadequate safety device, he asks us to determine the credibility of the plaintiff and his supervisor, the chief engineer, Mr. Kelly, at this juncture, because he says that that would be dispositive here, that to the extent that there's inconsistencies, as my colleague referred previously, to the extent that there's any inconsistencies that should defeat the motion for summary judgment. What do you say?
There is no inconsistency. There's no inconsistency in Mr. Kelly's testimony. There's no inconsistency in the plaintiff's testimony. And again, my position is, if you read Hill and its progeny, the fact that plaintiff didn't say everything about the accident that would have been necessary in a pleading or in a motion for summary judgment does not create an inconsistency, since both this court and the Court of Appeals has held that a plaintiff can get summary judgment even in an unwitnessed accident. It follows that where you have a witnessed accident where everything is actually consistent and you're not implying an inconsistency, the trial judge got this one exactly right.
We disagree, and it matters whether, for liability, whether plaintiff and his colleague are believed about how the accident happened. And it's not just like a case where it's an unwitnessed accident. And I'll just read from two of them. One of them is page 511 of the record. He went for a second opinion to Island Musculoskeletal, and here's what the doctor writes in his note on that page 511. He says, it's an evaluation of a 44-year-old man, a work-related injury on October 4. And he says he was at that job 18 years, 40 hours a week, plus overtime. His job requires working overhead with wrenches, reaching, pulling, pushing, grabbing, and twisting. Due to the repetitive nature of his job, he developed pain in the neck, right shoulder. And then, I'm sorry to repeat, but this is the C3 that he signed himself.
Counsel, well, that may be true, or that may be accurate, your recitation. It says nothing as to how the accident happened.
Oh, that says nothing, that doctor's record, that's correct, but he's taking a history of how the accident happened. It does in the W3 say, and by the way, there's inconsistency, which I don't think is significant, where plaintiff testified at his deposition that he fell off the ladder and landed on his back, boom. And whereas the witness sees him holding himself up on the thing.
I still think that these determinations go to the issue of damages. The jury can assess the credibility. The jury can assess whether there's a prior injury that was exacerbated perhaps by the accident, or the jury can determine whether there was a new injury that was created, don't you think?
But that's only under 240 if the injury happened from slipping or falling off the ladder. And it doesn't matter if he slipped off the ladder, fell off the ladder, grabbed that, that's the force of gravity. But the accounts that we've submitted and are identified in our brief do not show the gravity causing the injury. Have a fall or a slip, they don't refer to that. Under circumstances where it would be reasonable to do so, as opposed to the one report where it had just a few lines. Thank you.
Thank you. Bax versus InterEnergy Holdings.
May it please the court, August W. Heckman III, here on behalf of defendant appellant InterEnergy. Your honors, while on its face, this is an employment-related breach of contract case and not a criminal matter, what it really boils down to and what this court should focus on is a confession and a smoking gun. I'll address the confession first. The day plaintiff resigned, he separately emailed the board of directors, the CEO, and his colleagues, wherein he defined the nature of InterEnergy's business, the scope of his new employer's business, and acknowledged that he was going there immediately. In doing so, plaintiff confessed that he engaged in the specified conduct that automatically terminated his stock options under the stock option plan. Bit of background. InterEnergy employed plaintiff. InterEnergy is a power company that invests...
We understand the facts, honey. Facts, counsel, sorry. Please stick to the legal arguments.
Absolutely, Your Honor. With respect to plaintiff's confessions, I would point you to the 3 emails found at pages 330, 332, and 334 in the record. The day Mr. Bax resigned, he told the board of directors, which includes members of the compensation committee, he told them, I've accepted a position with the new company. The company, Thermion Energy, has raised, and this is a quote, $500 million in private equity funds to invest in the renewable and clean energy sector on heritage wind and solar projects in Mexico. In his email the same day to the CEO of InterEnergy, Mr. Bax describes Thermion Energy as, quote, a private equity-backed startup in Mexico that has raised funds to invest in wind, solar, and clean cogen activities in Mexico. And in his 3rd resignation email sent the same day to his colleagues, he describes his new employer, Thermion, as, quote, a new private equity-backed company formed to invest in renewable energy and clean energy projects in Mexico. Your honors, those confessions made the day of his resignation control the outcome of this case. The rest of the record is rife or full of Mr. Bax's attempts to recant those confessions, to explain away those confessions once he realized that they constituted specified conduct and the automatic revocation of his stock options. Further, Your Honors, to the extent that there was any legitimate dispute or we didn't believe Mr. Bax's confession the day of his resignation, we have the smoking gun email. The smoking gun email not only confirms that Thermion and InterEnergy are competitive, but the smoking gun is also a separate, independent form of specified conduct under the plan, i.e., the unauthorized disclosure of confidential information related to the company.
Counsel, was the language relating to the company broad enough to encompass the meaning here?
Absolutely, Your Honor, and your question perhaps has a predicate underlying inference of the language could have or should have said about InterEnergy. And it does not say about InterEnergy, it says related to InterEnergy. In order to obtain the confidential information memorandum, InterEnergy had to enter into a non-disclosure agreement with Citibank. And by the way, the individual at InterEnergy that signed that non-disclosure agreement was the plaintiff. By signing the non-disclosure agreement, InterEnergy contractually bound itself to protect the confidentiality of that information. Further, that information is about a business deal that InterEnergy is looking into, right? That's the whole point of obtaining the confidential information memorandum. Therefore, it's related to. I would point to the common sense.
Counsel, if Thermion is found to be not to be an industry competitor, how does that affect your position?
That would affect the position with respect to the specified conduct on the non-compete, Your Honor, but it would have no impact whatsoever on the disclosure of the confidential information. That is a separate, second, independent ground for revocation of the stock options.
How does the InterEnergy Code of Business Conduct and Ethics factor here?
It does and it doesn't, Your Honor. I don't think we need to get there. But to the extent the court was confused or there was some ambiguity with respect to how InterEnergy itself defines confidential information, and we didn't just stop at the level of signing an NDA to obtain it, we could look to the Code of Conduct and Business Ethics to see how the company very broadly defines the definition of confidential information. And I'll quote from the code: all non-public information learned as an employee.
Thank you.
I don't think it can get any more broad than that, Your Honor.
Thank you.
Thank you.
Your Honors, Michael Fasano for Respondent Appellant. May it please the Court. Your Honors, respectfully, we think that InterEnergy misses the point relating to the first issue that was presented by my adversary, which is whether Mexico, to begin with, is competitive with the businesses of InterEnergy. And that's where we see the ambiguity, and that's where we see the trial issue. The language is very specific, saying that Mr. Bax was not allowed to compete with the businesses, ES, of InterEnergy for 6 months after he left the company. What Mr. Bax did, he didn't admit that he was going somewhere that he couldn't go. He was telling people truthfully where he was going because he had a good faith belief that he could go there. Mainly, and the reason why he had that belief and was corroborated in the record by InterEnergy's employees. One of InterEnergy's managing directors clarified in his deposition that InterEnergy has businesses where it has offices. Those were in four places when he resigned. And they remained in those places for the 6 months after. They were Panama, Chile, Jamaica, and the Dominican Republic. So Mr. Bax chose to go to work in a country, to take a job as a CEO of an energy company in a country where they couldn't do, where not that InterEnergy could not do a deal. It's just they had never done a deal. There were no offices, and they did not have any businesses there. The reason why that also makes sense is because the chief.
Yes. So that what you're speaking about relates to the non-compete covenant, right?
Yes, absolutely.
Now, with regard to the non-disclosure,
yes,
the fact that you're alleging that they're not competitors, does that have any effect with regards to the disclosure?
No, Your Honor. I agree with the appellant that there are separate bases to terminate the stock options. There are three that they mentioned in their brief. One of them is the non-disclosure of confidential information. But Mr. Bax, what we're talking about, first of all, is a single email where Mr. Bax wrote to someone during the course of a 6 or 7 month courtship period to get a new job, where he said, basically, here, have a look at this document, which was a confidential information memorandum.
And your client concedes that sharing that document had nothing to do with his responsibilities or duties. In other words, he was not seeking a business partner on behalf of his employer?
Well, no, he actually was not seeking a business partner on behalf of the employer because the new employer couldn't do this deal. Part of what Mr. Bax has consistently said throughout the case is that he was going to a company, and there is evidence in the record that the company was only allowed to invest because they took Mexican pension funds in order to invest. They were only able to invest in companies in Mexico. This was a project that actually was transmitting power across international lines into Guatemala. And before we even get to that point, I think the more important thing to realize is that this was not inter-energy information. As Mr. Heckman pointed out, it talks about, the plan talks about information regarding inter-energy. The way that Mr. Bax interpreted that was that it was information that was generated by.
Do you agree that your client obtained this information, which was non-public as a result of being an employee of InterEnergy?
He obtained the information, which was not public. However, the information belonged to Citibank. The information did not belong to InterEnergy. InterEnergy was, there's evidence in the record that InterEnergy wanted partners, specifically for the project. So there's evidence that InterEnergy would have permitted, but for this lawsuit, and would have permitted the defendant, or sorry, the plaintiff to share this information. Additionally, I know that Mr. Heckman brought up the code of conduct. The CEO of the company has said that he did not promulgate a confidentiality policy throughout the company, did not know if it existed. That document is unsigned. There's testimony in the record that people don't recall receiving it, seeing it. We believe that code of conduct is something that was never, that our client was never bound by. The most important thing, though, Your Honors, that we would like the court to realize is that the document was not InterEnergy confidential information. It was not an internal board meeting. It wasn't internal pricing or valuation material relating to a project. It was a document that an investment banker gave to the company, yes, under an NDA, that specifically says in the document that it's the property of Citibank, Citibank's investment banking group. And Mr. Bax, yes, it's undisputed that he shared that document with someone from Thermion saying, have a look, before he left his employment. However, our position is that when you read the language, when it's regarding, that this information was not regarding InterEnergy, and it was not internal information that was proprietary to InterEnergy, it was information that belonged to Citibank. Thank you.
Thank you, Your Honors. Quick points. First of all, InterEnergy invests in and manages these energy assets, solar power, wind power. That's not disputed. They invest in them. All one needs to do is look at plaintiff's admissions and confessions the day he resigns. In each of those emails, he says, Thermion Energy invest in, these are his words, quote, invest in the renewable and clean energy, quote, invest in wind, solar, and clean cogen activities, quote, invest in renewable energy and clean energy projects. Where InterEnergy owns the actual assets that it owns at the time is irrelevant. They are actively seeking to participate in an investment in Mexico. That's the entire point of the smoking gun email, Project Maya, a Mexican power project. And I want to just hit on another quick point.
Counsel, your adversary says that the information contained in that memo was proprietary to an investment bank, not to your client. So what does it matter that it was disclosed?
First of all, Your Honor, InterEnergy signed the plaintiff signed an NDA on behalf of InterEnergy to accept that confidential information memorandum. And of course, it's not the confidential information of InterEnergy. It's not InterEnergy's pay data, profit data. It's confidential information about a deal that InterEnergy is potentially working on. To obtain that information, InterEnergy enters into the NDA. I would submit it therefore takes ownership or possession of that information. It's responsible, it's contractually bound to protect it. It's exposed to liability for breaching those promises. But The provision reads exactly as follows, and I quote from Section 2T of, may I just finish the
Yes.
quotation? Thank you, Your Honors. The grantee's unauthorized disclosure of confidential information relating to the company or its affiliates, not about the company and not regarding the company, relating to. Thank you, Your Honors.
Thank you. People versus Jerry Anderson.
Good afternoon, Your Honors. May it please the Court. Taylor Poore with the Office of the Appellate Defender for Jerry Anderson. Mr. Anderson was originally sentenced to 15 years on this case in 2002. 10 years later, he was summoned back in front of the court for resentencing because the original sentencing court forgot to impose the required PRS term. Even by the date of Mr. Anderson's resentencing in 2012, he had transformed. He had completed professional and peer support training in prison. He addressed the court, which he had not done at his initial sentencing. And the judge's decision at that point to stick to its original PRS sentence of 5 years rather than the minimum of 2.5 was unreasonably harsh, given the progress Mr. Anderson had made. In the interest of justice, this court should now reduce either Mr. Anderson's original prison sentence from 15 to 10 years or his post-release supervision sentence from 5 to 2.5 years, either of which modification would have a meaningful impact on his life now. This is, of course, the direct appeal for Mr. Anderson's conviction. So what's before this court is the plenary proceeding, the appeal from every part of the judgments below, including his plea, sentencing, and resentencing. And that means that this court does have the power to reduce both or either Mr. Anderson's prison term or his post-release supervision term, and has every reason to do so. And as I mentioned, a modification of either part of that sentence would impact his life. The events in relation to which Mr. Anderson pled guilty happened more than 20 years ago. This court has before it an extensive record that shows his progress and transformation since then. He was already clearly capable of making significant changes, even in the 10 years since his original conviction. And although this court is obviously restricted to the record on appeal, you can take judicial notice of the fact that he's been compliant with supervision and successfully earning less is more time ever since his release.
What was his release date? Would you remind me, please?
It was at the end of 2021, I believe. It was at the end of August. And so the studies we've cited in our brief have referred to the fact that supervision lasting more than about a year can be extremely unproductive and counterproductive, both excessively burdensome on Mr. Anderson as well as the providers who are supervising him. And extensive supervision, post-release supervision, does not make communities safer. Mr. Anderson is now 62 years old. He's almost 63. The practical significance of the sentence reduction that he's requesting would be extremely modest. But it would still have a meaningful impact on his life, and this court should reduce his sentence.
Thank you. Did you have a question?
Good afternoon, Your Honors, and may it please the Court. Jennifer Mitchell for the people. Defendant's bargain for sentence was lenient in light of the severity of his crimes and should not be disturbed on appeal. Defendant was facing 11 first-degree robbery charges, but he only had to plead to 3 in exchange for the very lenient sentence that he received in this case. 1 count of first-degree robbery alone carried a maximum determinate prison term of 25 years. And for the 3 charges that defendant pled to, he was facing a maximum aggregate prison sentence of 50 years. In exchange for his plea, defendant actually received the severely lenient sentence of 15 years, followed by 5 years of post-release supervision. And in exchange for his plea, he was able to have his sentences run concurrently rather than consecutively. This was a very serious case where defendant participated in 11 separate robberies within a...
What was his history during incarceration?
During his incarceration for this
Yes.
crime or previous criminal history?
This one, the 10 years or whatever the period of time was.
So he did, as defendant cites in their brief, participate in programming during his period of incarceration, which is definitely commendable. However, it does not take away from the seriousness of his actions.
Any infractions?
Your Honor, I am not sure at this moment about his record while incarcerated and whether he had any infractions.
Wouldn't that be telling? I mean, he was 40 years old at the time he committed this offense. But then, I mean, given his age, he would have had serious time to think about his history.
Yes, Your Honor. What I can say that I know, based on the record, is that after he was released for this underlying crime, which was actually back in, I believe it was 2014, he was then reconvicted of an unrelated offense in which he was incarcerated from 2017 until 2021. And that is when he was released, which would pause his period of post-release supervision and then continue on now. Since then, he's also been rearrested for unrelated charges twice. And again, all of this to say that while, yes, it is commendable that he did this programming while incarcerated, it doesn't change the fact that these were very serious crimes that he committed. There were numerous victims that were harmed based on his actions, and he is able to receive the relief that he seeks for his post-release supervision term.
Through the less is more.
Yes, exactly, through good behavior under the Less is More Act. And so for all of those reasons, the people ask that you affirm. Thank you.
Two very brief points, Your Honors. Mr. Anderson was reincarcerated on drug charges stemming from his lifelong addiction to opioids. I represented him on that appeal. He was injured on his construction site. A doctor prescribed opiates, triggering his relapse. There were no allegations of violence, and he served that time. The PRS time that he's now serving is actually the undischarged PRS time from the case we're now discussing, the one that's now on appeal. And additionally, just to quickly address the less is more, even assuming Mr. Anderson continues to get credit, as he has been doing, for every single day of less is more time that's available to him, which given the onerous requirements is not at all certain, a reduction from this court would still impact his remaining sentence, and I urge this court to reduce either his prison term or his PRS term. And unless the court has any other questions, we just ask that you reduce the sentence. Thank you.
Thank you. Thank you both. Art Capital versus Bank of NT, sorry.
Good afternoon, Your Honor. May it please the Court. I'm Matthew Press, Press Corral LLP for Appellants Art Capital Bermuda and Bluefin Servicing Limited. Appellants are appealing a $10 million default judgment that was entered after their counsel was mistakenly allowed to withdraw after it had failed to file an answer to respondents' amended counterclaims. The trial court first erred by entering a default judgment in this complex matter on a 122-page complaint with 331 paragraphs without holding an inquest. It's well established
Sir,
that...
as I understood your friend's point in his brief on this, and I'll try to, drill it down to its absolute essence, is that based on your client's own admissions and certain immutable facts, the damages calculation could be undertaken, and that there was no evidence that could be presented at the inquest or cross-examination of the counterclaiming defendant's evidence that would make a material difference on that calculation. How do you respond to that?
Well, Your Honor, respectfully, almost any plaintiff or claimant would want to make such an argument. It's kind of wishful thinking. This complaint, this counterclaim, is if this type of counterclaim is capable of having a clerk's judgment entered on it, which is effectively what this was, without an inquest, then it's hard to see what kind of complaint would not require an inquest after a default judgment. If CPLR 3215 has any meaning, then there is an inquest required, an opportunity to cross-examine witnesses and present other evidence. Now, what kind of evidence? It's well established that a default in the merits doesn't admit to a plaintiff's conclusion on damages, and the complaint or the answer in counterclaims. If I assume your honors have looked at this document, it has an enormous number of alleged payments that occurred on certain alleged dates, and each of those amounts would actually have to be proven to have been received, because under the waterfall and the loan participation agreements, the only amounts that the claimant in the counterclaims would be entitled to are amounts that its proportionate share of amounts actually received from the borrower. Okay, that's something that would have to be proved out. Also, a huge part of the claims in the counterclaims is claims for interest, which would have to be accruing from a particular point in time. What point in time? This is an extrinsic fact. These are they're countless alleged payments. So it's just not possible to establish an amount of interest without establishing the dates and the amounts of those alleged payments. And then, aside from those facts, there in the waterfall has takes servicer fees and expenses off the top. That was never accounted for. There are hundreds of thousands or perhaps millions of dollars worth of servicer fees and expenses that need to be deducted before you can even start distributing anything. Now, another important thing is contractual indemnity claims. There are these make-weight claims that they add up to as $2 million, which are basically duplicative of other amounts that on the base breach of contract claim. All of these amounts would have to be proven, and my clients should be entitled to demonstrate the costs and the servicer fees and expenses. And another thing is their phantom default interest claims. Butterfield has claimed entitlement to a share of default interest payments, but those payments were not actually made. These are just hypothetical payments. They would have to demonstrate that they were paid in order to claim a proportionate share. So these are all things that are needed, and this is why an inquest is required. Now, in the note of issue, Butterfield said that it had about $6 million in damages. When after the judge invited Butterfield to submit a proposed judgment, that was increased to $9 million. And there's no accounting for that. It's just a line in a proposed judgment. I would submit that if there's any case in which there must be an inquest, it has to be a case like this. I mean, this complaint is enormous. There's so many payments. And I think the important thing to focus on, Your Honor, is that the standard is you can only enter a judgment without an inquest if the complaint seeks a sum certain or a sum that could, with I believe simple computation, be computed, like a promissory note, where you have a face amount and then you have interest.
That's for a clerk's judgment, right? Now, here there was submissions, additional submissions permitted by Supreme Court before the justice undertook the damages computation, right? So there's sort of three different paths one could go down here. There's the clerk's judgment, which admittedly, grant you, is very rare. It has to be a sum certain. There is further proceedings before the judge with the papers, and then there is the inquest. So this judge here seemed to go down the middle path.
Okay, and Your Honor, I'm so glad you raised that. I believe there are only two paths. I believe if you can't get a judgment under Section A of 3215, then it has to be B. And when you look at B, B requires an inquest. There had to be an inquest.
Thank you. You have some
Thank you, Your Honor.
rebuttal.
Good afternoon, Your Honors. May it please the Court, my name is Joel Rosner. I'm counsel for respondent, the Bank of N.T. Butterfield & Son Limited. The threshold issue in this case is appealability, which is to say the appellants lack standing to bring this appeal. This is an appeal from a judgment granted on default, which was granted after the appellants defaulted and failed to oppose the bank's motion for default judgment on its counterclaims and to dismiss their affirmative claims in June of 2020. The settled case law says there's no appeal or order that's lies from the entry on default. In addition, appellants have not made any argument about the dismissal of their affirmative claims in this appeal, and they've abandoned that argument. They nevertheless contend that they have standing to bring this appeal, pointing to this summary judgment motion that was made in the fall of 2021. But that motion is a bit of a red herring. Appellant Bluefin did not join that motion and has no relief there. And the motion itself by Art Capital was denied as untimely made beyond the court's deadline for dispositive motions and without good cause. In addition, it contested facts that had been admitted by virtue of its own default on the counterclaims.
But I think your friend pointed out that those admissions would be all traversable allegations of liability, but not damages.
So in this case, Your Honor, there's a bit of both here. The allegations in the counterclaims were detailed allegations about what payments were owed, what payments were collected, what payments should have been collected, and what payments should have been distributed. Those are not damages allegations. Those are the allegations that were integral to the breach of contract, to the merits. The damages calculation is simply you take the formula in these loan agreements and you take the dates payments were made or supposed to be made, and you apply the formulas. The bank's motion for default judgment didn't just rely on its verified counterclaims. It had an evidentiary submission attached to it where one of its officers who supervised this arrangement went through calculations on the damages. So the only real contest here was the mathematical computation of payments made and what payments flowed to the bank as a result of that. To give one example, the appellants themselves have participated in the submission of a report from a special master who looked at all the payments made by the borrowers and admitted there were $9 million of payments made, that a large portion of which should have been returned to the bank. The bank's $6 million in principal, and a raft of other interest and other payments due under the agreement that the appellants unlawfully withheld. So the damages, while there are certainly a lot of different mathematical components here, it is in the end an issue of settled payments, a settled formula, and not really any real dispute, certainly no dispute raised in the papers about actual evidence that will be put forward to challenge any of this computation and any of the damages that were awarded. And I would point out that the amount that was in the judgment, the excluding prejudgment interest, is precisely the amount that was sought in the motion for default judgment on the counterclaims. It did not change one iota from June of 2020, although the judgment was actually not issued for a year and a half after that.
What about the disparity, or perhaps you would characterize it as one, between the damages that were requested in the note of issue and then the damages subsequently demanded a couple months later in the motion for the default judgment?
So the damages in the note of issue were referenced the principal repayment, which was undisputed, and referenced the fact that there was no doubt that the principal the bank had paid, which was $6 million, had to be repaid to it. The motion thereafter took calculations, some of which were in the complaint, or most of which were in the complaint, the counterclaims, and put them out in a total mathematical calculation. But there really isn't a disparity. One was just saying, hey, it's at least this amount, and we don't know the total. And then the motion said, here's the total. We've done all the calculations. Here's the evidence. Here's the allegations of fact. Here's the affirmation of our officer attesting to calculations. So there really isn't, the bank was consistent from June of 2020 until the judgment was granted. Even though interest actually should have accrued in that interim, it didn't recover that interest. It didn't seek that interest. It stayed with exactly what was in the June 2020 motion that appellants defaulted on and did not oppose.
Also, was there any dispute as to whether the payments that were made by the borrower were actually made?
No. As I said, the special master's report, who examined the payments that were made in consultation with the plaintiffs, affirmed that $9 million were paid by the borrowers, including full repayment of the principal on all the loans at issue in the motion for default judgment. And during discovery and during other aspects of the case, the documents were put forward to identify how much was being paid on given dates. We had wire confirmations.
The judgment amount here include any payments that were not covered by the special master's report?
The only thing that's in the judgment that was not included in the special master's report are the what is called indemnity interest and the default interest. Several loans went into default, and once that happened, a higher rate of interest should have kicked in. The appellants refused to collect money at that higher default rate. We saw damages for that because it was a substantial amount of money that they were obligated to collect and refused to. The indemnity interest payments were when appellants received money and did not distribute it, they had to pay additional interest to pay the bank for the time of money that it was losing in getting these payments, and also to make sure that they were paying on time. Thank you, Your Honor.
I'd first like to address the standing argument that was made. As I set forth in the brief, all the issues on this appeal are issues that are actually contested before the trial court, so I believe there is standing. As to the damages, I think, as Your Honor noted before, for purpose of liability, all those same facts are appropriate, but for purposes of damages, these amounts had to be proven. It's nice that they put in a witness and that attached some computations, but my client was entitled to cross-examine that witness and present its own evidence. I think that's clear under CPLR 3215B.
Counsel, the special master's report, does it accomplish what it is you're saying that they had to do in terms of proving those payments?
So the special master report, I'm glad you raised this, Your Honor. That was something that the special master was tasked with identifying payments that went from one party to another. And one or more of those borrowers actually had other loan agreements with my client. And so one of the fallacies of relying on the special master report is, first of all, none of it's proven, none of it's ever been adjudicated, but there are other loan amounts that are coming in that aren't attributable to the loans or the specific loans at issue in this case. And all of that is the kind of thing that would have been brought up in an inquest, but we never had an opportunity to do that.
Sir, did you request an inquest?
Yes, I did, Your Honor. Yes, in the last few pages of our record, after the oral argument, when Justice Reed announced that he was intending to grant a default judgment, I wrote a letter, and I think I said it several times, begging the court to grant an inquest, and you'll see I made precisely the same arguments and raised precisely the same points at that time, and I was frankly very surprised that the court would enter a $10 million judgment without an inquest. And one other point that I failed to make before is that the numbers that were presented in the proposed judgment included interest up to the date of the judgment. Nevertheless, the court added $1.2 million of pre-judgment interest on top of that, and that would be inappropriate. I mean, that alone is a $1.2 million difference that shouldn't have been added, and if had an inquest taken place, it would have been possible to present that to the court. If Your Honor have no further questions, I rest on the remainder of my brief, and I request that this court reverse the judgment of the trial court. Thank you very much.
Thank you. Thank you both. Contreras versus Mall 1 Bay Plaza.
Good afternoon, Your Honors. Michael Schneider with Kennedy's Law on behalf of the appellant, Mall 1 Bay Plaza. Our position is pretty simple. This was a premature dismissal of the case. It's a third-party action. My client had contracted with the third-party defendant, Electrical Illuminations. It's something they had done previously in years past. They had a pattern and practice of doing this. And in this particular instance,
There's no question that you entered into this agreement after the accident, right?
Well, that is the question. So the question is,
Well, no, I don't know that the document was signed and everything was done after the accident.
the execution of the document was 2 days after the accident.
There's no question there.
No question on when it was executed.
And the document also says something about during the continuance of its work, or something to that effect.
So,
Is that right?
counsel, I'm glad you raised that, Your Honor. Counsel raised that in his opposition brief. What the actual indemnity agreement says, and the area where it talks about the continuance, it's talking about the insurance obligations of electrical illuminations. Our motion, our cause of action was for contractual indemnification. The indemnification provision is very clear. All it says is, and I'll read it for Your Honor, it says, to the fullest extent permitted by law, the contractor, which is the third-party defendant, will indemnify, defend, and hold harmless the owner and managing agent, my clients, from all claims, and it goes on, but essentially what it says is it has to arise out of or in connection with the performance of the work. There's no doubt that this incident happened during the performance of the work that Electrical Illuminations was doing. The continuance wording that counsel raised was essentially a diversion. It's in the first paragraph, and it specifically talks about the policies of insurance that are to be obtained.
There's no language in the contract, however, indicating that the intent of the parties was that this would be retroactive.
You're absolutely right, Your Honor. The contract itself does not use the term retroactive. It's the affidavit of Ms. Ashkar that we submitted because she's the one who negotiated the contract each year, including this year, and said, of course, that was our intention. They just got sloppy. They didn't get the document signed in advance of doing the work.
In your course of dealings, was there a situation where the contract was signed after the work had commenced? Because it seemed to me that this was the first time that actually happened.
Yeah, exactly, Your Honor. So Ms. Ashkar's affidavit was, again, she was the one with personal knowledge of this. Each time they had done it in the past, the contract was in advance of the work. This time it wasn't. They just forgot to get it signed. That's all that happened here. It would almost fly in the face of logic that they were willing to sign the document a couple days into the project to cover the rest of it, but they didn't intend for it to cover the couple days before.
Counsel, I have to tell you that for me, this case reminds me of, like, Contracts 101. How are you suing pursuant to an insurance policy, pursuant to an agreement to obtain insurance and indemnify the plaintiff that is signed post-accident? How do you say that this applies to the accident retroactively? I see it as so ABC. It doesn't apply retroactively. I was looking at, in the record at page 106, an email that was sent pertaining to something different, October 2018, where the email says, attached police fine PO number 1652, assigned to your proposal referenced above, and also attached, please review our insurance requirements attached and submit a COI/indemnification form signed for review and approval. That's not what happened here, where the accident occurred on November 8th, 2020, and the agreement was signed November 10th, 2020. I don't see that there's any parallel.
Yeah, so I mean, the Flores case is the case we cited that allows for this very situation where two parties that are dealing, that have a pattern and practice of dealing, and if they forget to get the document signed before the work starts to be performed, extrinsic evidence can come in to establish that the party's intention was retroactive. And the other thing I'll point out is this was a pre-discovery.
What extrinsic evidence do you have here? What extrinsic evidence do you have here? The only thing I saw in the record was the August 17th work estimate and the October 28th purchase order. I mean, that seems to be what they were working with.
Well, the sworn affidavit of Ms. Ashkar she's the one who was negotiating it with them. She's the one who had the conversations with the people from Electric Illuminations each time they did this, including this very time. So her sworn testimony is evidence of the negotiations and the intentions of the parties.
Thank you.
Thank you, Your Honor.
May it please the court, my name is Daniel Kotler from Lester Schwab, Katz and Dwyer, on behalf of third-party defendants, respondents.
Could you address counsel's argument with regard to course of conduct and why we should ignore the fact that this was signed 2 days after the accident and look to course of conduct of the parties?
Absolutely. There are, I think, two aspects of course of conduct here. In terms of what happened in the year of the accident that we're dealing with, the course of conduct establishes performance of the estimate and the proposal, and that language laying out the documents. This isn't a situation where you had a detailed contract laying out all of the aspects of performance and what's to be done that just never happened to be signed. The performance is related to the two documents describing what is to be done. Those are separate and apart from the indemnity agreement. In terms of a supposed historic dealing or course of conduct of, oh, we always did this, they always signed it, they never put it in, third-party plaintiffs, the mall didn't actually provide any evidence of that. They put in evidence that, oh, we asked them to do it, but not that they actually got these things signed, not that this was the course of action. I don't believe the clarity of what was even asked for in this time, as opposed to insurance versus the precise execution of this. It's not clear based on her having put anything in on the mall's affidavit that there was any course of dealing of, oh, we sign these every year, we just.
In other words, there was an affidavit, but there was no evidence from prior contracts showing.
Precisely, Your Honor.
Dates
there was
or
the affidavit, but no documents, no executed agreements from years past. And to the prematurity argument, these are documents to which the mall was a party. How is this premature? They don't need discovery to get any of this. They don't need subpoenas to get any of this. These are their own documents. If they have them, they can produce them, but they haven't.
Does the procedural posture of this, though, in your to your friend's benefit, this wasn't summary judgment, right? This was 3211?
Based on the pleadings and the agreement that's right there, they could have put papers in. They could have become more than that, but there's nothing more to be done here. Their own complaint, their own claims fall short because the document on which they base it is signed 2 days, it's executed 2 days after. It would have been easy to say, hey, just predate this. Yes, we all know it's the 10th, but sign this as if it was the 1st.
So is there any corollary to the, any parallel to what I was referencing before, the 2018 document at record page 106, where insurance, where forms were signed or approval prior to the commencement of work was required, where the insurance requirements were attached? Is there any parallel with what happened in 2020?
I don't think there's a parallel, and I don't think even 2018 would get us there, because this is talking about insurance. This is separate and apart from indemnity issues. That was precisely the point that my colleague here made in saying, oh, well, continuance refers only to insurance. I think continuance is part of the document, and it's the only language. There's clearly no retroactive language.
Does your client contest that it was a requirement that there be insurance and indemnity in order to start the work?
I'm sorry, can you say that again?
Does your client contest what your adversary is saying, that in order to begin the work that they require the insurance and the indemnity?
Yes, that's clearly a contested point. I think there's no evidence of, they asked for an indemnity, but they didn't insist that there be one in hand before the work began. The historical precedent that the third-party plaintiff at the mall points to shows a history of work being done without insisting on these agreements, because they don't put in any executed indemnities. They seem to have had a history of, we'd like this, oh, you're not giving it to us, okay, we don't really care that much.
Thank you.
That seems to be the historical precedent here.
Thank you.
Thank you, Your Honors.
Your Honor, in response to what was just being said, once again, I'll just hearken back to the affidavit from Ms. Ashgar, which clearly says.
The council just said that it says that, but it doesn't provide any document proving that.
And I think that gets to, so counsel's making an argument essentially about the credibility of the affidavit. And we are at a 3211 pre-discovery motion to dismiss. The affidavit itself is sworn evidence from the person who was involved saying this is
Seems
exactly
it's not the
what we
best
did.
evidence. If you wanted to put in the best evidence, you would have, if you would put in that.
I mean, I think that may be an argument that can get made later on. Maybe it's a great argument for trial if we do not have copies of those documents that support what the sworn affidavit says. But the sworn affidavit is from the person who had the dealings. And counsel was just referencing the fact that within that affidavit, there wasn't any support for some of the arguments that are being made. The affidavit harkens back to the emails, to the communications each time they did this, and it specifically speaks to the person on behalf of Electrical Illuminations who agreed to get indemnity before the work started. And I'll also just go back to the very same point. This work was ongoing work that went on for a period of time. The idea that Electrical Illuminations only agreed to sign this contract a couple of days in, knowing it would then apply the rest of the way, but they didn't intend to have it apply for the few days before that, just doesn't really make logical sense. Thank you.
Thank you both. Webb versus New York City Transit Authority.
May it please, excuse me, may it please the court, Tim O'Shaughnessy from MTA Law Department for Transit. This was plaintiff's motion for summary judgment, so that any conflicts in the testimony must be resolved in Transit's favor on this motion. Bus driver testified, he said something to the effect of it's dangerous out there, please exit to the front. That's also reflected in his report, which is in the record, and in the supervisor's report, which is in the record.
Didn't the bus driver, as much as he did say that, open all doors, didn't the bus driver, as much as he did say exit to the front, open all of the doors, inviting people thereby to exit through the back door or the middle door?
Well, he did open all the doors, that's true. I'm not sure that I would say that that was inviting people to exit through the back door when he was saying, he was inviting, really, or suggesting at least that people exit through the front door.
But he has a duty here to make sure that the area is clear. And while he said that the area in the front was clear, there would be no point to open up the doors or allow anyone to exit anywhere that you knew that it wasn't safe.
Well, our position is that the law says that he was required to give the passengers a place where they could safely disembark from the bus.
So you're saying one place, even though there were 3 doors, one place was sufficient?
Yes, and he did that. That was the front door. There's no question that there was no ice or snow on the sidewalk outside of the front door. And in fact, although this is a dangerous condition case, the fact of the matter is, although plaintiff fell when he went out through the third door.
Enough? In other words, one safe exit was provided, but isn't it dispositive that a dangerous exit was also provided, one of which the driver himself had notice and purportedly gave notice about to the passengers?
Under the law, only one safe place was necessary. And there's a question of whether, it's a dangerous condition, but just how dangerous was it is a question that goes to the reasonableness of what the bus driver did, because in fact—
but that doesn't make sense, counsel. So you know that. The bus drivers have the ability to say, everybody out the front door, everybody out the back door, and that's the end of it.
He has that ability,
but it didn't happen here. It didn't happen here. All the doors opened, and the people could go out. As my colleague is saying, they were really being invited, go out whichever door you want.
The doors were open. I'm not sure that they were invited. And I wanted to make the point that although the plaintiff fell, after he fell, a number of people exited through that door without falling.
But that doesn't prove anything. It just may mean that they stepped differently. What does that prove? That they saw somebody fall and they walked around?
Well, it goes to how dangerous the condition was and how reasonable the bus driver's actions were. I think if the third door had stopped at the edge of a cliff down to a river, then it would be a different case.
You saw the photos, you saw the video, you saw the condition of the sidewalk and the street. So did we.
Yes, and a number of people were able to traverse it safely. So all we're saying is that in our system, generally, the first pass at the question of whether there was a departure from ordinary care is made by the jury, and we feel that that's what should happen here.
Thank you.
Thank you.
Good afternoon. My name is Elliot. Sorry. Good afternoon. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the plaintiff respondent. I think Justice Gonzalez and Renwick, you obviously understand my points.
Well, let me ask you this. Why aren't there questions of fact here based on what counsel argued? That there were 3 entrances, but he did provide one safe area, and he said to people, leave through the front. Why isn't that?
Well, it's not even really a question of fact, because we can concede that I'll concede for the purposes of this argument that the driver made some kind of announcement and that the front door was at least safer to exit through, okay? But the fact is that the driver did something affirmative here. He literally gave a green light to go through a door.
Did he compel the passenger to exit through the third door? Because normally that's the standard, right?
Did he compel it?
Whether the common carrier compelled or suggested to the passenger to take a hazardous path. That's normally the standard, and I think we could acknowledge this is a unique case. Normally, we're not talking about multiple points of exit from the single vehicle. It's normally there's a single point, and that's the focal point whether there's a hazardous condition. Here we have this unique circumstance where there's 1 bus, 3 doors, 1 safe, 1 clearly unsafe.
Right, but in terms of compelling, I would argue that giving the green light is I don't really like the word compelling. No one held a gun to anyone's head, okay? But when you...
I don't like it either. I'm quoting from Miller versus Vernon from the Court of Appeals.
I know that, but like I said, when you take an affirmative action, which is turning on the green light, that makes it different, okay? The driver acknowledges that this was a hazardous condition. That's not in dispute, okay? The driver acknowledges that he could have changed the switch a little, and that would have prevented the egress through the door that led to the hazardous condition. When he didn't do that, and he basically says, I didn't do it because I just wasn't thinking about it.
Counsel, how do you respond to your adversary's argument that the bus driver provided 1 safe way to exit the bus, and that's it? He satisfied his burden.
I think that's a misinterpretation of the law. I think if you provide 1 safe place, that's wonderful, but when you make an invitation to exit to another thing that you know, another exit that you know is unsafe, that has to negate that. Okay, there are too many circumstances where a verbal warning is not going to be enough. I don't want to say that that's why this happened in this case, but there's going to be passengers who don't understand English. They look for the green light.
Thank you.
Thank you.
If there are no questions, we'll rest on our brief.
Thank you. Your co-counsel saved you there. Appellate Construction versus La Rocca.
Good afternoon, Your Honours. May it please the Court, Justine Claire Moran, of counsel to the Topo Law Firm for petitioners appellants Appellate Construction and Wayne Bellett. In this Article 78 proceeding, appellants contended that DOB is not authorised to suspend and revoke Bellett's rigger's licence on the law and on the facts.
So, counsel, I want to ask you right off the bat, where do you get that premise from? Because the administrative code says something different. At 28401, it says that DOB has a jurisdiction to suspend or revoke a license. And at 28101.3, it says that failure to comply with the code means all New York City construction codes. And here, DOB found 9 specifications, also known as violations, that were pretty egregious, and that, according to the, I guess it would be the plaintiff in the underlying case, it led to the death of one of the construction workers, one of the people who erected the scaffolding. So how can you say that DOB has no jurisdiction to suspend or revoke a license?
Your Honor, DOB only has powers to suspend or revoke that are given to it, delegated by the code.
Well, let me ask you a different way. Is the rigger's license subject to Article 401 of the New York City Administrative Code?
It is, Your Honor, in the circumstances where there has been work under the license, and it's undisputed here that Appellate were acting as GCs and not as riggers.
Isn't there language in Article 401 that encompasses the building code? So that 401, the code means all codes, including the code, the building codes covering the rigger's license, have to comply with 401.
But I think it's important, Your Honor, for the court to understand that Appellate was not acting at this project in its capacity as a rigger.
But counsel, is there a requirement that in order to suspend the rigger's license, that the incident that happened was because of the use of the license? I don't see that anywhere.
If Your Honor looks at Code 28401.19.3.1, it actually specifies that for a rigger's license, there has to be a finding of guilty after proceedings before the ECB.
Just give me that code one more time, please.
Certainly. It's 28401.19.3.1. It is the code section which applies to riggers' licenses, which is what is at issue here.
So that's a specific provision with regards to the rigger's license, but there is a general provision also that all licensee must follow the administrative code and the building code, correct?
That is correct, Your Honor, but in this instance...
So in this instance where the rigger's license was not being used and what led up to the incident, what the argument is from DOB is that he's still subject to the requirements of the administrative code and the building code.
He's subject to the requirements of the code as they relate to his trade. Here we've got a situation where GOB decided that he was responsible under the code for the actions of licensed and qualified subcontractors. In effect, my client is simply a general contractor. He hired specialists to erect the scaffold.
Licensed and qualified
subcontractors.
Yeah, I'm listening to you, but according to one of the violations issued by DOB, these people weren't trained to do the work. Let me just look this over here. They didn't have the training to use the support scaffolding. They didn't have design drawings. They didn't have, I guess the plethora of violations for me is mind-boggling here. You're saying that the GC had absolutely no responsibility here once a subcontractor was hired.
Absolutely, Your Honor, because the code, the provisions of the building code, which form the specifications underlying these charges, do not contain vicarious liability or strict liability. Somehow, DOB has implied it. But in fact, the code says that you have to have very specific training to install scaffold, for example. My client's not qualified to do that. He hired someone who was. That is the party who is responsible for violation of the code.
Is he with the rigger's license or with, okay, he wasn't using his rigger's license, but given that he's the GC, he has a responsibility to look at what the codes are, I'm sorry, the other groups are doing, know what they're doing. And in this instance, as was referred to, there are a number of egregious violations. But why isn't the penalty of revocation authorized under even 28-401.19 that you referred to as a reasonable exercise of Department of Buildings Commissioner's discretion?
It is not reasonable, Your Honor, because my client is not the person responsible.
But you just said he's responsible for the hiring here. I'm sorry, the red light is on, so you can answer that question on the phone.
Thank you, Your Honor.
May it please the court, Jameson Davies for the respondents. This court should affirm Supreme Court's decision. Following the tragic death of a worker on one of Bellett's work sites, a DOB investigation revealed numerous violations of the building code. DOB moved or revoked.
I'm just going to ask if you would just slow down.
Sure, I apologize, Your Honor.
And speak up a little bit.
DOB moved to revoke Bellett's special riggers license, and the revocation provisions permit revocation for, under the specifications they were charged with, any act involving negligence, incompetence, lack of knowledge, or disregard of the building code and related laws or rules.
But your adversary says that Bellett was the GC and didn't actually do the installation of the scaffolding. Therefore, as GC, it had no responsibility here.
Correct. That is their argument, and they sort of characterize it as vicarious liability, but that's not really how the administrative code works. Under 19, we charge them directly with the things that they directly did to violate. We're not saying that they were vicariously liable for the actions of their subcontractors. We're saying that their actions violated those two sections, and that those sections are extremely broad. They don't relate only to actions undertaken under the special riggers license. It's any act endangering public safety and welfare, and any act that's in violation or disregard of the building code and rules.
The Department of Buildings is currently advocating for a change in the law that would sort of tighten this up, right, this area. How does that play into this?
So the advocacy of the change in the law would go to the regulation of general contractors, and it would basically, right now, a general contractor just has to have a registration, not a license, and there are less requirements for that. So it would require a license and require additional, give DOB additional ability to revoke those licenses for violations, but it doesn't have anything to do with DOB's power to revoke specialty licenses. If you read through the legislative history, specialty licenses aren't at issue at all. No one who's opposing, all of the people who testified who are opposing that legislation, no one mentioned that it could, expand DOB's ability to revoke specialty licenses, because that's just not what the legislation was about. And it actually would remedy the sort of inconsistency that Bellett points to, where the general contractor could not be charged by DOB because there was no license for them to be revoked, for DOB to revoke. But
just as a matter of clarity for me,
sure.
There's no allegation here that the work that was being done under this riggers license, right?
That's correct.
Okay.
And a different question, there was no permit here, and there's two arguments or explanations posed by Bellett. One is that it wasn't required to get the permit because it wasn't doing the actual work. The other is that there was no need for a permit because having eyeballed the building, or it was shorter than 40 feet.
Right.
Based on his experience, long-time experience as a general contractor.
Just to take those questions in order, first, he was responsible for ensuring that all the requisite permits were pulled. Even he can't contract away his responsibility to make sure. And he even testified. If you look at 453 in the record, he testified specifically that if the height was above 40 feet, that he needed to pull a permit as a general contractor or make sure that it was done. As to the second point, that really goes to substantial evidence, and there was overwhelming evidence in the record that the height was higher than the 40 feet. There was the fact that the building was 6 stories tall and it went all the way to the top. There's photographic evidence in the record of the height of the scaffolding, and the ALJ was well within his powers to make that determination, and only has to be supported by substantial evidence, not even a preponderance of the evidence, and there was plainly sufficient evidence for that. I'd just like to make a quick point, if I could, about the rigorous license that you mentioned, 401-19.3.1. That provides that if there are certain violations, either in front of the ECB or for failure to get the correct insurance, then the special rigorous license must be suspended. But that doesn't limit the court's or the DOB's powers under 28-401.19, which provides 18 separate reasons, many of which don't necessarily relate to the specialty license at issue, to revoke a license, such as fraudulent dealings. Even if you look to the oath cases that they cite on pages 14 to 16 of their reply brief, a lot of those didn't involve conduct under the license. For example, the Nobel case involved attempted bribery. It wasn't work under the license. The Bernardus case involved failure to pay wages and benefits, not directly a violation of work under the license. The Buono case involved violating a completely different code, similar to here. They violated a different section of the building code by failing to comport with the plans that they had submitted for the construction they were doing. And the violation was found under the same subsection of the statute that we found the violations here. Unless there are any other questions, I'd urge the court to affirm, please.
Thank you.
Briefly, Your Honours, DOB's theory of why my client is liable is its interpretation of 28401.2 to mean that GCs have to know all rules, all DOB rules, all sections of the code under Chapter 4, which is clearly impossible. Intro 2278, which Your Honour referred to, was seeking to make GCs like Ballot vicariously liable and responsible for site safety. That's not currently their liability under the code as written. And my client had no idea that his license was in jeopardy for work not performed under it and for not knowing the responsibilities of other licensed contractors that he hired. Frankly, if the DOB's decision is upheld, every GC in New York City will have to stop work.
Also, you're framing it as if your client did not know the responsibilities that the subcontractor was subject to. But as I read it, your client is arguing that it didn't need to pull the permits, that the scaffolding wasn't over 40 feet, that the square footage was under 100. So there's a difference in argument there, isn't there?
Thank you for reminding me, Justice Rodriguez. I would like to correct that if the court looks at the record, pages 444 to 445, what my client actually testified was he had been to the site to price the job, he'd agreed the work area. He never agreed that he was responsible for the height of the scaffold. It was an exchange with his attorney. He knew the work area was 35 feet up. He wasn't expecting a higher scaffold than that.
Thank you.
Thank you.
Thank you both. I'm going to call the next case out of turn. It's going to be Wanberger versus Lucani. Fernandez will be called last.
Good afternoon, Your Honors. May it please the Court, Stephen J. Cizik, Cizik Law PLLC for Plaintiff Appellant Suzanne Wanberger. The lower court had directed the parties to an ADR and mediation session. Prior to the start of that, Mediation session, plaintiff requested to have her business partner participate on her behalf and speak on her behalf, due mainly to plaintiff's inexperience in mediation and court proceedings. While being a foreigner, she did speak English well, but preferred to have an additional representative assist her with the mediation. Mr. Goldstein also had extensive knowledge of the facts at hand and plaintiff's position.
Counsel, I'm going to ask you a sort of a secondary question, but I want to get it out of the way now.
Sure.
This case was dismissed without prejudice, is that correct?
Yes, the problem, statute of limitations, Your Honor.
The statute of limitations has run.
Certainly yet.
I see, okay.
There
So
was
you
no-
would have under CPLR 205A 6 months from this decision to bring another action?
Well, frankly, it really was believed to be an abuse of discretion. We did a motion to.
I understand, but I was asking a separate question.
I didn't, the question was.
I was asking that you would have 6 months after, depending on what happens here, 6 months after the decision in this case on appeal.
On appeal. We would
Pursuant
have
to 205A to bring the action again.
We would have 6 months.
Yes.
That's good to know. Go ahead. While there was no objection, may I continue? Sorry.
Yes, sure.
While there was no objection by defendant to have Mr. Goldstein speak, the mediation.
Sure, time is precious here. Let me kind of cut to the chase,
Sure.
at least from my end. What rule or rules were you alleged to have violated that resulted in the dismissal of this?
Frankly, that's a good question, Your Honor. The judge's decision specifically said failure to follow the rules and leaving the mediation. But plaintiff did not leave the mediation, and I did not leave the mediation. Mr. Goldstein left the mediation a little early, but we did not leave the mediation. Plaintiff herself and me, as counsel, did not leave the mediation until we were excused and until it was determined that an impasse had been reached and the parties were not going to resolve the matter that day.
When were you given notice that dismissal might eventuate based on the conduct of Mr. Goldstein?
None, until we received notice that dismissal would happen when the case was dismissed.
Didn't this issue come up at the preliminary conference?
Excuse me, sorry?
Didn't this issue come up at the preliminary conference and then in the trial court give notice then?
And within a couple of hours after that conference, the judge dismissed the case.
But what happened at the conference?
There was the issues of discovery, and I guess the judge then discovered a few, facts of Ms. Boyce's email after the conference. But clearly, there were things brought to light to the judge or things that swayed Judge Bannon's decision following that conference because the judge gave no indication during that conference that there was going to be a dismissal or that.
Prior to the date, I'll just call it the sua sponte dismissal order. Prior to that date, were you given an opportunity to challenge the alleged conduct on the part of Mr. Goldstein?
We weren't even given a chance to respond to Mrs. Boyce's email alleging the conduct, let alone the dismissal itself.
And was the preliminary conference, I probably know the answer to this, but I'll ask it anyway, was that on the record?
I'm fairly certain it was. I don't recall at the moment. I do believe most conferences on the record. I can't recall at the moment, Your Honor.
So you asked for an opportunity to respond and it was denied?
I believe we did, and we did.
But you just said that you didn't even have an opportunity to respond.
I mean, at the conference and after dismissal. Before the case was dismissed, we had no opportunity to respond.
So at the conference, you asked for an opportunity to respond to the arguments. It was denied. You weren't permitted.
At the conference, I believe, I really don't remember all the facts then. I believe we started to respond, but it wasn't discussed at length. It wasn't really a main issue at the conference. It was almost an aside.
What kind of conference was it?
It was the judge was actually setting discovery.
So it was a preliminary conference.
It was more of a status. The case had been around for a while. There was some discovery already done. So it was more of like a compliance or status conference.
And in your experience, is the subject of dismissing a pleading usually explored at a preliminary conference?
Almost never. As far as I've never recalled that. Frankly, it was quite a shock, and the fact that the entire case was dismissed based on an email, a very subjective and capricious email that was written by a mediator based on an argument and, miscommunication, perhaps a misunderstanding between her and a representative. I barely got a word in at all during the mediation. My client, the plaintiff, was asked to speak. Mr. Goldstein tried to speak on her behalf, and that's where everything broke down. 2 hours after non-related conversations by the mediator to run up the clock.
Thank you.
Thank you.
Good afternoon, Your Honors. Jeffrey Miller for the respondent.
Counsel, you didn't move for dismissal, did you?
I'm sorry, say it again.
You didn't move for dismissal? Is that right?
In the underlying case?
Right.
No.
Case we're here on.
There was no motion. There was no motion to dismiss the underlying case, Your Honor. No.
And in fact, the way that it happened is that preliminary conference, June 24th, right? The email was forwarded on June 30th, and that same day case was dismissed.
That's my understanding. We're not counsel. My firm was in counsel below, but that's my understanding based on the record.
So there was no hearing, no opportunity for both sides to explain what happened? What did the court base its decision on?
I'll answer that in 3 ways, Your Honor. The first is that in the respondent's reply brief, I'm sorry, the appellant's reply brief, they admit that the lower court judge had the power and discretion to impose this exact sanction if the situation was as we described, the appellee, which is the same as the court described.
And
That's
how
on
would
the
you-
that's on the
how
bottom
would
of page
the court
5.
come to that determination as to what happened in that mediation?
What happened in the mediation? I couldn't hear the
If there
beginning.
is if your friend has conceded that if the conduct that was claimed to have occurred on Mr. Goldstein's behalf had in fact occurred, then dismissal would have been an appropriate penalty. What was the appropriate manner in which to ascertain the facts that would support that dismissal?
I'm not sure that the appellant preserved that issue for appeal, Your Honor. They made a motion to vacate and didn't allege in the motion to vacate the order any of the things Your Honors are asking. The appellant's position is the facts are different than the mediators.
Okay, so there's a variance of facts being provided, correct?
But never made any of the claims that you're making that could preserve these things for appeal. But there wasn't a variance of fact. There was not a variance of fact on key issues, including the fact that this Mr. Goldstein, who is the appellant's apparently fiance, authorized to speak at the mediation, also texted the mediator after the fact with threatening remarks.
I want to get back to the variation of facts. What were the variation of facts that you're saying? You said there was.
No, I'm saying to the extent there's any variation, it wasn't on the key facts that support dismissal.
What was it on then? What was?
Counsel put in an affirmation. There was no affirmation from affidavit from Mr. Goldstein in the motion to vacate. There's no affidavit from the appellant.
What was put in that you're
There was
saying?
just an affirmation from counsel who said, who didn't disagree that Mr. Goldstein and the mediator were talking over each other, but was making the claim that it was the mediator that was in the wrong and not Mr. Goldstein. Did not address Mr. Goldstein's language, his voice, his speaking over her, that it was rude. Did not address the fact that after the mediation, continued to text this mediator. I mean,
But still raised issues. But still raised issues with regard to what happened in the mediation that was not addressed.
I don't. If you read closely the affirmation that was put in, it does not contest that they were disputing with each other.
So,
and that they
sir,
were
let me ask you a very fundamental question then. Let's view this record in a light most favorable to your client, to the mediator, and to the trial judge. What principle of law, statute, or rule authorizes dismissal of the complaint?
So I think I would answer that in 2 ways, Your Honor. One is, I'm not sure that's an appropriate issue for appeal, only because the appellant acknowledged in their submission to this court that the lower court has the, quote, power and discretion to impose sanctions, and he goes on, in a situation similar to this.
To impose sanctions and dismissal are not synonyms.
Well, that is a form of sanction, Your Honor. And the appellant does not claim in his brief, the lower court judge didn't have the right to dismiss this case. What are we doing here?
All right, well, I'm curious, because to me, this strikes me as very strange. So I'd like to know, given that we know there's a very clear body of law from the Court of Appeals that says courts lack the inherent power to dismiss cases, particularly for laxity in the prosecution thereof. So what is the normative basis on which this complaint, the ultimate sanction that can be imposed in a civil action, what is the normative basis to dismiss the complaint for the conduct that occurred, again, viewing it in the light most favorable to yourself, the mediator, and the trial judge?
Failing to follow the court's orders, which included the order directing the reference to the mediation, which specifically provided that the parties had to follow the mediation rules, which specifically precludes this type of conduct. I mean, here, Your Honor.
All right, I have them here. You just tell me which rule authorizes dismissal of a complaint.
Well, it authorizes sanctions or any other remedy that the judge finds necessary, and I think that's 10H2.
Okay.
And again, didn't follow the preliminary conference order. I understand the sequencing as the court's laid it out.
Would the conduct here by Goldstein rises to the level of extraordinary circumstances that would justify dismissal?
I didn't hear the beginning of the question, Your Honor.
Would you argue that the conduct here alleged by Mr. Goldstein would give rise to extraordinary circumstances to justify dismissal of the action?
I would, because it wasn't just that the guy was being rude, and I take, I wasn't there obviously, but I take it from the record and the mediator's emails, and the fact that counsel's affirmation did not dispute a lot of things in the mediator's email. It ruined the entire mediation. The first 3 hours of court-ordered mediation are free. That all went away, and they couldn't use up that. So they didn't have an opportunity to mediate. So you have the court saying, I think this is a proper case to mediate, and you have the appellant, and it is the appellant because this was her authorized representative, destroying the 3 hours that they had to have this free and essentially destroying the mediation opportunity. And what is the appropriate remedy for that? Now, the rules say any sanction the court, I'm paraphrasing, the court allows, but my direct answer to your question, Your Honor, would be yes.
One quick question. Do you, what is your spin on the without prejudice? In other words, based on the CPR provision that my learned colleague raised earlier with your friend, they would have the right within 6 months, assuming arguendo.
Yeah.
There was an affirmance here to bring the action again?
I haven't looked into that issue. Obviously, they haven't availed themselves of the 6-month filing yet. And if they have the right to do it without prejudice, they have the right.
They can't, yes, of course. Thank you.
Thank you.
Circle back, Your Honors, on this
Counsel, before you say anything,
yes.
I had a question actually from the prior questions. I need a clarification. You wrote in your brief that the mediator wrote a CYA letter to the ADR coordinator. I'm not familiar with CYA in any context other than vulgarity, so could you tell me what the definition of CYA is? Because otherwise, I'm astonished that that would be used in an appellate brief.
It was an error and put in inadvertently and a typo, and I do sincerely apologize for that to you and to the court, to Your Honor, to the court. Please accept my apologies for that. That was an absolute accident.
Counsel, we've done a lot of discussion about, is any of this preserved?
Is any of this?
Is any of this preserved? Any of the issues that we're discussing here, did you preserve those issues? Right, because what we're here on is, you're saying that the court should have vacated its decision.
Right.
Right, but you're not challenging the decision itself.
It should have been initially to challenge. It should have been, we are technically challenging the dismissal. It should have never been dismissed. Frankly, we filed a motion to vacate, and that's what we chose to appeal. By the time the motion
well, that's
the motion
the
to
only
re-argue.
avenue to appeal, correct?
I'm sorry,
you can't appeal as of right from a sua sponte order. So you have to make a motion to vacate. So what was the thrust of the argument that you made in your underlying motion to vacate?
Well, it was more, it was that the court abused its discretion, and the court went way beyond reasonable conditions based on a subjective, one-sided email to dismiss an entire litigation. And I just want to circle back to the 2.5 hours when the discussion got started. Mr. Goldstein never opened his mouth until 2.5 hours in. It was the mediator killing time herself, talking about art and talking about engagement and opening up the discussions as delving into non-relevant issues as much as she could so that she could eat up the clock. Mr. Goldstein didn't have a chance to open his mouth until 2.5 hours in. That being said, it also is notable that Judge Bannon's order specifically says that the ADR order expressly provides that failure to comply full with all the ADR rules may result in the impositions of sanctions and other appropriate action. The parties appeared for mediation, and that goes on to explain some behavior, but doesn't really explain how the rules are broken, except that plaintiff left the session, which is inaccurate. Plaintiff never left the session until she was excused. As I mentioned earlier, Mr. Goldstein left the session.
Thank you.
Thank you, Your Honors.
Thank you both.
The case should be decided on its merits.
Fernandez versus Bright Leasing. Justice Higgett is recused from this case.
Good afternoon, Your Honors. May it please the court. Jonas Weig with his Weig Law Firm for the appellants, Bright Leasing Corp. And Naveed Akhtar. Your Honors, this is a summary judgment motion, and as a result, the foundational principle of law, which has been established by legion precedent in the Court of Appeals and each of the departments of the Appellate Division, is that the facts must be viewed in the light most favorable to the non-movement. There are multiple triable issues of fact that were presented in the motion practice below that the trial court failed to view in such a light, and viewing the facts in that manner indicates that summary judgment was inappropriate. Specifically, the speed of the co-defendant, the movement, is a triable issue of fact, because under the VTL, if one is speeding, then that can equate to negligence, and there can be more than one proximate cause of an accident. Number two, the positioning of the vehicles on the roadway. The co-defendant himself may have been required to yield to the non-moving defendant by virtue of the positioning, distance, and speed, and the time involved in the positioning on the roadway. And lastly, the fact that the defendant had stopped his vehicle only somewhat into the intersection, leaving sufficient space for the co-defendant to pass safely in front of him, and yet the co-defendant failed. None of these facts are speculative. They are all definitive and must be accepted in the light most favorable to the non-movement. Defendant Akhtar testified at his deposition that he had stopped at the stop sign fully, he had checked to the intersection to the right, he had only partially passed the crosswalk and partially moved into the intersection when the co-defendant vehicle appeared to his right, driving at a high speed and accelerating. He testified that he came to a full stop with room in front of him for the co-defendant to pass. But the co-defendant failed and continued accelerating and struck the Akhtar vehicle. And he reiterated, Akhtar was still within the crosswalk and only partially in the intersection when the accident occurred. He stated that there were 10 seconds between his seeing the co-defendant and the co-defendant striking his vehicle, which means that the co-defendant had this entire span of time within which he could have seen and reacted to the Akhtar vehicle. But he failed to see what is to be seen, which, as the courts have repeatedly held, a driver who has the right of way has to see what there is to be seen, and failing to see what there is to be seen constitutes negligence. These multiple aspects all present a scenario of non-negligence by the non-movement and proximate cause and negligence by the co-defendant, who failed to avoid the accident, who failed to drive around the vehicle which had left the intersection sufficiently clear for him to do so, and was driving at excessive speed in violation of VTL 1140, multiple provisions of VTL 1180A, and established precedent. It has to be accepted as fact that the co-defendant left enough space in the intersection and was at a full stop when the co-defendant vehicle struck him while it was accelerating. Indeed, the co-defendant admits in his own testimony.
What about the testimony of the two passengers that said that the stop was a very quick stop?
That, Your Honor, I would initially say that, again, inferences must be given to the non-movement. The fact that that testimony exists doesn't mean that it will outweigh the non-movement. However, that testimony does not in any way conflict with Akhtar's testimony, who stated that there were 2 stops involved. He briefly stopped, pulled into the intersection, observed the co-defendant 10 seconds before the impact, and stopped again. It should also be noted, each of the plaintiff passengers who testified admitted that neither of them saw the co-defendant vehicle before the accident. Moreover, the co-defendant didn't see the non-movement defendant before the accident. The only observer who saw all of the
More
players...
slowly, counsel, you're going fast like the car.
Apologies. The only observer who saw all of the vehicles involved in the accident and is able to testify as to the events therein is the non-movement, who explained a non-negligent reason for the accident and whose testimony was disregarded.
Thank you.
May it please the court, Grace Cho from James F. Butler Associates for the respondents. Appellants argue that the respondents were speeding at the time of the accident. There's actually no evidence as to my client's speed. As the appellant actually testified, when he was asked if he can estimate the speed of my client, he stated that he cannot estimate. Along with the fact that, as appellant's counsel agrees, the plaintiffs did not see my client's vehicle before the accident, and thus there's no evidence as to whether my client was speeding at all. Regarding the position of the vehicles, appellants actually testified that the front passenger side of the vehicle struck the driver's side of my client's vehicle, which shows that there was no evidence as to the fact that the appellants had already entered the intersection when the accident occurred. As you know, the court pretty much, there's case law that determines that there's no duty to watch for and avoid a driver who might fail to stop at the stop sign. There's no dispute as to whether the appellants stopped, before the accident.
So, counsel, this is a motion for summary judgment.
Yes.
Was there any testimony offered or an affidavit offered explaining that there was sufficient space or insufficient space for your client's vehicle to pass safely by the taxi cab?
There was no testimony as to whether there was any sufficient space except for appellant's testimony that they did stop, but there's actually appellant themselves testified that they were actually moving at 0.1 mile per hour. As VTL 1172A states, the appellant was required to stop before entering the crosswalk. The violation of VTL 1172A is negligence as a matter of law, which the appellants testified that they did enter the crosswalk slightly before the impact.
Do you take into consideration, on this record, shouldn't consideration be given to the plaintiff's testimony? The plaintiffs testified that they saw it was a turn in progress, making left. The impact was very great.
Right, plaintiffs pretty much testify that appellants failed to stop. They do say that there was a brief stop, but a lot of the testimony pretty much states...
That's different. Saying that there was a brief stop indicates that there was a stop, although brief. That's different from saying there was no stop.
Well, there's also testimony from the plaintiffs that states that there was a van in front of the appellant's vehial. The van
he closely followed that van into the intersection.
Continued to proceed. And so, yes, there was a brief stop, but that is not the issue at heart, because despite the stop, they had to yield to the right-of-way of my client, who did not have a stop sign at the time.
Thank you.
Thank you.
Your Honors, to the point that there's no evidence of the speed of the co-defendant vehicle, the evidence is, of course, the appellant's testimony that it was driving at excessive speed, and he was the only observer who saw all the vehicles in play. Moreover,
Don't we have case law that you have to be able to identify the speed to a certain extent?
the appellant testified that it was driving very rapidly, approaching at high speed, and accelerating further. Moreover, the courts have held in Patty versus Fenimore, for example, that the force of the impact itself can be a determining factor in the speed of
So you're saying it's the force of the impact, not somebody's just guess as to how fast he was going, whether it was 30 or 15 or...
Your Honor, I would say that it's both, but I would not use the word guesses. The appellant is not guessing that the co-defendant was driving at excessive speed. He's simply not able to put a precise number on it. He's not a radar machine. The force of impact is additional evidence because the co-defendant vehicle only came to arrest several car lengths after the point of impact. Moreover, no one is able to dispute the positioning of the vehicles on the roadway because no one else saw them. And the co-defendant, the movant, admits that he never saw the defendant appellant's vehicle before the impact. The mischaracterization of the appellant's testimony, he was fully stopped at the time of the impact. He testified that he had been moving at between 0 and 0.1 miles per hour before he was forced to apply his brakes, which is when he saw the co-defendant's vehicle 10 seconds prior to impact. That's at the record of 282. He stated that he was not moving at the time of the impact, 281 to 282 and 285, and that a full 10 seconds had passed from the time he first saw the co-defendant until the impact, record at 284. The record is very clear. The defendant, the appellant, Akhtar, had only partially proceeded into the intersection, which remained sufficiently clear for De Jesus to avoid this impact. De Jesus failed to see what there was to be seen while operating at excessive speed in violation of multiple provisions of the CPLR. The lower court's failure to take these into consideration, these tribal issues of fact, warrant reversal of summary judgment. And if there are no further questions, we'll rest on the brief.
Thank you both.
Thank you, Your Honors. Thanks for having us. I'm sorry? Oh, you did great. No, I don't think so. No, I also agree.
Really, I wrote that in like a day. Alrighty.
Have a good night.